서울대 인공지능 정책 이니시티브에서 주최하는 AI와 시장 컨퍼런스에 오신 것을 환영합니다. 저는 이니시티브의 공동 디렉터를 맡고 있는 서울대 로스쿨의 임용 교수입니다. 서울대 인공지능 정책 이니시티브는 매년 인공지능 정책에 관한 국제 컨퍼런스를 개최해 왔습니다. 올해 컨퍼런스는 코비드-19로 인하여 웨비나 시리즈로 기획하여 진행하고 있습니다. 이렇게 버추얼 컨퍼런스를 진행할 수 있게 된 것은 후원해 주신 분들과 참석자 여러분들의 관심 덕분입니다. 이 자리를 빌어 모두에게 감사를 표합니다. 오늘 웨비나는 시리즈 세 번째 세션입니다. 알고리즘과 경쟁을 주제로 런던 스쿨 오브 이코노믹스의 니엄 던 교수님께서 발표를 하실 예정인데요. 그 전에 참석자 여러분을 위한 몇 가지 안내 사항을 말씀드리겠습니다. 오늘 발표는 한글 자막과 함께 영어로 진행됩니다. 여러분들의 줌 화면의 채팅창을 눌러서 보시면 유튜브를 통해 제공되는 동시 통역 채널 링크가 게시되어 있습니다. 동시 통역을 듣고자 하시는 분은 별도의 기기로 유튜브 채널에 접속할 것을 권장합니다. 다시 말씀드리면 지금 보고 계시는 기기로는 볼륨을 줄여 영상을 보시고 음성은 핸드폰과 같은 별도의 기기로 유튜브를 통해 제공되는 동시 통역을 듣는 것입니다. 질문은 발표 중이나 그 후 언제든 채팅창에 자유롭게 올려주시면 발표가 끝난 후에 제가 던 교수님께 전달하여 답변을 들을 수 있도록 하겠습니다. 오늘 연사인 니엄 던 교수님을 간략하게 소개하겠습니다. 던 교수님은 말씀드린 대로 LSE에서 경쟁법과 이유법을 강의하고 계십니다. EU 경쟁법에 관한 대표적인 교과서 중 하나인 존스 앤 서프린의 EU 컴피티션 러 최신판 공저자이기도 하시고 유럽에서 가장 주목받고 있는 젊은 스타 학자 중 하나이십니다. 던 교수님께서는 학계 외에도 아일랜드 경쟁위원회의 변호사 등을 역임하면서 집행당국 쪽에서의 경험도 가지고 계십니다. 그럼 알고리즘과 경쟁, 진화하는 법과 정책이라는 제목으로 던 교수님의 발표를 듣겠습니다. Niamh, we've gone through the introductions and the floor is yours.
Wonderful. Have we got the slides coming? Yes, wonderful. Good afternoon, everyone. It is a great privilege and pleasure to be participating in this seminar series. Thank you so much to Professor Lim and to Seoul National University for inviting me to take part. My contribution to the seminar series is entitled Competition in the Era of Algorithms, Evolving Law and Policy. And what I'm really going to focus on today is the question of how artificial intelligence technology, specifically the use of algorithms by businesses, can create market problems and the extent to which these market problems can come within the scope of jurisdiction of the competition rules, and how competition law has thus far evolved, been applicable to sort of provide a solution of sorts to these problems. I'm also at the end of the presentation going to look into the future and ask, does competition law need itself to evolve in some ways? Does it need to be augmented or reformed with additional types of regulation to provide further solutions to the sorts of problems we see in the digital economy, specifically created by the use of algorithms? I'm going to be focusing on EU competition law, partly because that is my own area of specific research, but also because I think in the EU you see a particularly rich use of competition law to address a variety of different market problems created by artificial intelligence technology, created by the use of algorithms, but the sorts of problems that we see in the EU and the sorts of solutions we see in the EU have very broad application, not least because when we talk about the digital economy, it's a global market. The players we see in Europe are sort of found in very many markets worldwide. When I use the term algorithms, I'm using this very broadly to encompass a very broad range of technology, from search engines or the algorithms that power online advertising to the algorithms that set and track prices in e-commerce markets online. So it's a very broad range of technology, but you can kind of see a number of different patterns emerging in terms of the sorts of market problems and the sorts of solutions that competition law can present. So my, thank you. My research question generally, or what we're going to be asking today, is how does EU competition law address the increasing use of algorithms in modern markets? And I'm going to suggest that there are 4 key scenarios that we can see in the literature and the practice thus far: robot cartels, algorithms as a fact of the market, algorithms as aggravators of harm, algorithms as normal competition on the merits. And then we're going to, as I say, look into the future beyond existing competition law and consider options for reform. Next slide, please. So the first scenario is the one I'm calling the dystopian scenario. This is sort of the science fiction scenario. That is robot cartels. It is a fear that at some point in the future, the recurrent use of algorithms by multiple different operators within markets, multiple competitors, will result in collusion occurring, that those algorithms will, independently of the businesses that actually apply them, learn that it is more profitable to form a cartel than to compete vigorously, and so the algorithms will start to engage in anti-competitive collusive behavior. If you look at the literature on algorithms and competition law, this is the #1 topic of interest. Almost everything that has been written by academics in particular on this topic focuses on robot cartels, on the risk of algorithmic collusion, and on the problems that this might create for competition enforcement in this market. The most famous work is a book called Virtual Competition by Ariel Ezrahi and Maurice Stuckey. They're scholars, one is working in the UK, one is working in the US, and they consider the problem, the various ways in which it might arise. They consider how competition law might apply here, and they look at some of the limits of competition law. And this book has prompted a whole series of other articles subsequently where commentators agree and disagree, and they consider how competition law might need to change to address specific problems. The reason I'm not going to focus on this today, even though it is perhaps the most glamorous example, it's certainly the most dramatic, interesting problem involving algorithms that might occur, is that at the moment it does remain in the realms of science fiction. There have been no real world cases actually dealing with the problem, identifying problems of algorithmic collusion, autonomous algorithmic collusion, and trying to figure out, can competition law apply to these instances. There have been a couple of cases where algorithms were used deliberately by cartelists to implement a cartel. So you have the Trod GBI cartel in the UK and the United States versus Topkins case in the US. Both of these cases actually had very similar facts. They involved the sale of decorative art posters online on the Amazon Marketplace platform. The sellers of posters agreed to implement a cartel, and they used price-setting algorithms, price-setting software as the means by which they agreed prices and implemented those elevated prices. So algorithms can be a tool by which to implement a cartel, and that certainly has arisen, and that was those cases, they were sanctioned as violations of Section 1 of the Sherman Act, as violations of the equivalent of Article 101 TFEU in the UK. And there is also some evidence in terms of economic research that suggests that algorithms may be able to learn to engage in anti-competitive behavior. The Calvano paper is a quite well-known one, which is doing the rounds at the moment. These were a bunch of economists who conducted a lab experiment with some Q-learning algorithms. They got the algorithms to engage in price setting in parallel, and they discovered that eventually the algorithms quite quickly learned that it is more profitable to set higher prices, sort of engaging in a form of tacit collusion, than to set low competitive prices. So it is possible that this might be a problem that emerges in future. I'm certainly very happy to discuss the possibility in the Q&A, but I'm not going to talk about it today because my focus is cases that have been taken, and there isn't really any jurisprudence on this yet. So I am going to discuss instead 3 scenarios where we've seen actual practice. The first is where the algorithm is a really important market feature which has to be understood and taken into account in order to know, to have a proper understanding of how the market works, and thus why the behavior is anti-competitive. But in this scenario, the algorithm isn't really part of the abusive strategy. The algorithm is just a facet of the market which has to be taken into account by the competition authority. The 2 examples I'm going to talk about for this scenario both come from online advertising markets. The first is the Guess case from 2018, which was an infringement decision taken by the European Commission. So Guess is a manufacturer, a clothing manufacturer. It entered into a series of anti-competitive vertical distribution agreements with authorized retailers. Amongst the restrictive clauses it placed on its in those vertical agreements that it placed on authorized retailers was a prohibition on bidding on keywords in the Google AdWords system. So Google Ads provides advertising services to retailers. In order to buy Google Ads, you bid on keywords. If you win the bidding process, if you win the auction, then you have the ad, and it is published by Google on various platforms, and you have your online advertising. Google just had a blanket prohibition on authorized retailers bidding on those keywords, so they couldn't access the Google Ads system. That was considered to be a by-object breach of Article 101. And of course, the Google Ads system is powered by an algorithm which figures out what's the most profitable way from Google's perspective to sell ads, how those ads can be best placed to be most effective for retailers. The second case that I want to talk about is the Google Search AdSense decision. So this was a 102 decision, so targeted at Google itself as a dominant undertaking in the advertising markets in Europe. It actually focused on Google's AdSense product. So AdSense isn't targeted at retailers, it's actually for publishers. If you are an online publisher, so you have a website, whether you're a newspaper or you're a blog or whatever it might be, if you publish content and readers come to your website for that content, you typically want to monetize your website with ads. You use Google AdSense to put the ads on the website and have a revenue stream as a result. In the AdSense case, Google was fined €1.5 billion for violating Article 102 for having what was called a relaxed exclusivity policy, which meant that while publishers were free to buy ads both from Google and from other online advertising providers, they had to give the most profitable placement, which was really at the top of every website. They had to reserve that for Google. And so that sort of quite significantly disadvantaged rivals of Google. So in both of these cases, the behavior at issue only makes sense as an anti-competitive strategy. You can only understand why it's harmful because of how the underlying algorithm operated. So it was hugely important for the competition enforcer to understand how AdWords worked, how AdSense worked. The key issue in Guess was that the defendant wanted to lower its online advertising costs by reducing the price of keywords due to lower competition. So Guess itself advertised online through the Google AdWords platform. It bought advertising space. It itself had to bid on keywords. The more businesses that were bidding in the auction process for keywords, the higher the price Guess itself would have to pay. It wanted the lowest price possible, and so it simply forbade its authorized retailers from participating in those auctions, which advantaged it with lower advertising prices, but of course diminished competition in the retail e-commerce market as a result. In Google AdSense, how the algorithm worked was it charged a higher price for better placed advertising because it was much more profitable. Readers are much more likely to click higher placed ads, whereas if the ad is placed at the bottom of the article on the blog or on the newspaper website, consumers are very unlikely to see it and very, very unlikely to click on it. So you can't earn very much money from that. And so the Google's practice, its exclusivity policies, took advantage of, knew about how the AdSense algorithm worked and how it engaged in pricing and what was profitable, and was designed to take advantage of that, to maximize Google's profits as a result. But what's important about these cases is while the algorithm here presented a distinct market feature that could be manipulated, while you really had to understand how the algorithm worked to understand the abuse, it didn't determine the abuse. It was not dispositive of the abuse. And I think the most important point is that the same abuse could easily have arisen and had as significant anti-competitive effects offline in the brick and mortar context. So the fact that we've got algorithms here is part of the market story, but it doesn't determine the abuse itself. In terms of understanding how this could be the case, I think if you compare, say, the Google AdSense case to an offline advertising market, so you might have a local municipality which has many billboards which are located along highways. That local municipality may want to enter into an agreement to sell space on the billboards with the leading advertising company. If the leading advertising company tells the owner of the billboards, you have to give us access, exclusive access to the billboards on the really busy highways, on the where you've got the largest number of viewers, so you've got the largest number of people passing by. You can sell space on the billboards in the suburbs where there are very few people. They're not going to be seen to whoever you want. Well, you'd have pretty much exactly the same type of abuse. You'd have the same sort of anti-competitive behavior, completely absent algorithms outside the context of the digital economy. So the second scenario that I think is worth looking at, and I should say in these cases, the Commission does not dwell on the fact that we're dealing with algorithms at all. They are not concerned about the digital nature of these markets. They just treat it as a fact of the market. The third scenario that I want to talk about is where algorithms make a difference and where the digital context actually does seem to impact upon the harm, the nature of the abuse, and in this particular instance, in fact, justifies applying much older case law in a very modern context. The example I'm going to give you for this is a series of infringement cases involving resale price maintenance. So for those of you who may not be familiar, resale price maintenance is a type of vertical price fixing. It typically arises where a manufacturer agrees with a retailer the price the retailer is subsequently going to charge to consumers. So the manufacturer is setting the price to be charged to third parties. RPM is a pretty common commercial practice in many markets where it is permitted. It has always been treated with a great deal of suspicion under competition law because it has a tendency to reduce price discounting at the retail level. So it leads to higher retail prices, which is something which is very problematic, treated with a great deal of suspicion from an antitrust perspective. In the EU in particular, it has been treated as a by-object restriction of competition since a series of cases in the 1980s under Article 101. The big case here is Bino. Bino is an interesting case to be relying upon today because it's pretty much the exact opposite of the sorts of technology-heavy markets that you see in the digital economy. It is very far from artificial intelligence, from the use of learning algorithms and so forth. Bino involves the sale of physical magazines and newspapers from small shops, from small kiosks in Belgium in the 1980s. In this case, the European Court of Justice said RPM is a by-object automatic restriction of Article 101, so it's always going to be prohibited under Article 101, and you need to try and justify it as a result. However, there has been in the decades since BNO, there has been an increasing recognition of the more ambiguous nature of vertical restraints. Probably the most important case here is a US Supreme Court decision called Legion from 2007. But there have also been a number of cases in the EU, Maxima Latvia in 2015, Coty in 2017. And these cases together suggest that we should be very wary of automatically prohibiting vertical restraints, that they are much more ambiguous, that they often generate significant efficiencies. And I think they really do call into question whether BNO is still good law, whether we should still follow BNO today. And the final point I think to make before I talk about the actual cases here is that since the decentralization of enforcement in 2004, the European Commission hasn't really pursued vertical cases at all. It left them to the national competition authorities while it focused on cartels and focused on dominance cases. But surprisingly, in 2018, the Commission began to take vertical enforcement cases again. This was prompted by its its e-commerce sector inquiry as part of the digital single market strategy. So it surveyed e-commerce markets in Europe. There was a final report that was issued in 2017, and the report said that there's a growing use of vertical restraints in internet sales markets across Europe, and the Commission has started to use antitrust law to regulate that problem, including 5 infringement decisions taken against RPM practices in the online sphere. One of these was Guess. As I mentioned, Guess had multiple different restraints at issue, but there are also 4 further cases involving sellers of technology, of digital technology equipment, so Pioneer, Philips, ASUS, and so forth. The really interesting aspect of these cases is that despite Maxima, Coty, Legion, this growing recognition that the by-object condemnation of RPM may not be appropriate, the Commission takes a very traditional, conventional view and just applies the BNO precedent from 1985 in the digital context in 2018. What explains this? So you've got this older, arguably quite dubious precedent being applied very straightforwardly in the digital context. Well, the key factor in these cases seems to have been the widespread use of pricing algorithms. So it was the use of this very modern technology, the widespread use of essentially forms of artificial intelligence in these markets, which justified this very traditional, conventional, quite formalistic application of the competition rules. And it's quite interesting to, if you read the cases, to understand how the use of algorithms came into effect here. So pricing algorithms were used by manufacturers in these cases to essentially enforce the RPM policies. So the technology exists today that manufacturers like Guess or Philips or ASUS, if they have RPM policies, they can use algorithms to scrutinize the pricing of their authorized retailers to make sure that those retailers are adhering to the RPM requirements. So scrutinizing the pricing practices of retailers, which enables detection of lower prices rapidly, systematically, and thus enabling those manufacturers to go to any retailer who is cheating, any retailer who is not obeying or following the RPM requirement, and essentially enforcing the rules against them, making sure they raise their prices. So the use of pricing algorithms makes it much more straightforward, it makes it quicker, it makes it cheaper to actually enforce RPM from a manufacturer perspective. But perhaps more interesting is the effect of the widespread use of pricing algorithms by the online retailers themselves. because in most of these markets, how prices were set by retailers, they didn't set their prices independently in the e-commerce sphere. They actually delegated that to pricing algorithms. And typically, the algorithm would go out into the market, survey the prices being charged by other competing retailers, and set the price being charged by retailer X to the lowest price in the market to make sure that retailer X was charging the lowest competitive price so that their offering was competitive to consumers. This meant that if you had cheating by even just one undertaking in the market, one retailer charges a price below the RPM price, this results in what the Commission called online price erosion. The pricing algorithms used by the other retailers would all adjust downwards. They would meet that competitive threat, and so you'd have wide-scale price reductions across the market, which would benefit consumers in the form immediately of lower prices. Conversely, it means that if you have RPM policies, you have cheating by one undertaking, which is keeping the overall price level down. If the manufacturer can detect that and can successfully persuade that retailer to raise their prices to the agreed price level, the higher price level, then everybody else in the market is also going to raise their prices automatically as well, because the algorithms will track that and move upwards. And so the successful enforcement of an RPM policy in these sorts of markets can be very, very anti-competitive. It can have very significant ripple effects across the whole market, because the manufacturer just needs to identify one business charging below the competitive price, persuade them to start below the agreed price, persuade them to raise their price, and not only will you deal with the problem of price cutting by that undertaking, but you will have everybody else also charging a higher price as a result. And so you have these across the board price increases as a result of the use of pricing algorithms, which meant that in these markets, RPM, even if it's ambiguous in theory, in practice, it was likely to be very anti-competitive. It was likely to be harmful. And so the use of algorithms here didn't change resale price maintenance, which has been a recognized commercial practice for centuries, but it does make it more harmful. It confirms the fact that in this particular market, this practice is something that ought to be prohibited outright. So tipping the balance in favor of enforcement. I think it's an interesting case because it's a very old precedent. It's a very new type of market, e-commerce, but it's the nature of e-commerce confirms the continued application of the very old rule against RPM. So the fourth and final scenario that I'm going to talk about before I move on to look at sort of future prospects for enforcement is maybe the most interesting. It's the notion that the operation of an algorithm, which is objectively designed, independently, autonomously run, could itself represent competition on the merits, could be I suppose, the personification of a well-functioning competitive market, so that departing from that algorithm, deciding to interfere with, to modify the algorithm in some ways, becomes suspicious from a competition law perspective. The headline case here is the Google search shopping infringement decision taken by the European Commission in 2017. This is a very well-known case for two reasons. First, at the time, it resulted in the largest fine ever imposed by the European Commission, 2.4 billion euro, only to be eclipsed by the second fine imposed on Google in 2018, again by the European Commission. And it introduced the concept of self-preferencing. And so self-preferencing is perhaps the most important emerging theory of harm under Article 102 when it comes to the digital economy. It relates to vertically integrated dominant undertakings where they operate platforms and they favor their own services within their dominant platform at the expense of competitors who also use the platform. And it's a theory of harm in a number of ongoing investigations in addition to the Google search shopping case. What was at issue here is the two markets we're talking about are the general search market and the comparison shopping market. So in Europe, Google is by far the market leader when it comes to the provision of general search services. At the time of the case, it had an 85% market share in almost every national market in Europe and had held that market share for at least 10 years. So very durable market power, a very clear dominance. And that dominance stemmed not initially from anti-competitive behavior, but because the Google algorithm was so effective. It was such a good piece of technology. It was constantly being improved, a lot of investment, innovation. It really reflected, it provided a lot of value to consumers. So very highly effective technology. On the other hand, Google has been a lot less successful when it comes to comparison shopping. So comparison shopping is a type of specialized search engine. It relates to e-commerce, buying online. If you are a potential consumer and you want to buy, for example, maybe a pair of Nike running trainers, you can go to a comparison shopping website, type in the type of trainer you want to buy, and the comparison shopping website will find various offerings across the internet, and you can compare prices, you can compare terms and conditions, whatever it might be. As I say, historically, Google has been very weak in this market. The products it's developed for comparison shopping don't really work very well. And so the core of the Google search shopping case was Google's efforts to improve the performance of its comparison shopping product, not by improving the algorithm, because it didn't seem to be very good at really able to do that, but by distorting the rankings for comparison shopping products within its general search engine. And so what it did was, it did two things. It modified the general search algorithm in two ways. In terms of the rankings of its own comparison shopping product, it changed the algorithm, it manipulated it, so that its own search product would rank higher than the normal organic operation of the general search market. It kind of gave it a bit of a push up the rankings so consumers would be more likely to click on Google's own comparison shopping products. And in terms of rival products, it systematically demoted them in terms of their what would be the organic ranking. So if a comparison shopping product would ordinarily have ranked 3 in the search results, Google got its engineers to change the algorithm so that that result would be pushed down to the second or perhaps even the third page, so that nobody was ever really going to click on that comparison shopping product coming from the Google, if they're accessing it via the Google search engine. And in this way, they discriminated in favor, or they self-preferenced their own product compared with rivals. And this was considered to be an abuse of dominance. If you think about it, though, it's really quite an interesting idea, because it seems to assume that the normal, ordinary operation of the Google search engine, the organic operation of the search engine, reflects competition on the merits, reflects the competitive outcome, so that a deliberate effort to distort that, to change those results, to manipulate the search engine to the benefit of Google, has to be seen as something suspect. And I think you can really defend this position. There are lots of criticisms about how the Commission built the theory of harm in Google search. Google is a controversial topic because they pay for so much academic research. But so it's kind of difficult sometimes to see the clear view. But I think there is a genuine question that might be asked: if Google search engine is of such superior quality that it has had a market-leading position for 10 years across the European Union, why depart from it in this instance, if not for exclusionary purposes? And what I like about this example, when you compare it with the dystopia of the market of the robot cartels examples, is that it's a much more positive view of algorithms, that algorithms can make markets more competitive, at least where they operate independently and objectively. that we shouldn't necessarily be suspicious of technology. It's not the case that technology will always go wrong, will always result in increased market power or exploitation of consumers. Where the technology is well designed, where it has consumer need, consumer want in mind, and where it is free from manipulation and interference, then it can actually make markets work better. So just some very general overarching obligations on the interaction between competition law and algorithms before we move to looking forward to the future briefly. Algorithms are definitely part of the furniture in modern markets. They are a recurrent feature, particularly when we're talking about undertakings that provide services in the digital economy, that provide services online. So understanding how competition works requires understanding the role that algorithms play in directing, in structuring, in influencing that competition. This, of course, may be quite a complex task if we're talking about black box algorithms, so very complicated algorithms where it's quite difficult to see from the outside what they do or how they operate. This would be a complex task for computer scientists, not just for lawyers. But the precise operation of the technology isn't actually necessary when we're talking about competition law. You don't have to understand how the algorithm is itself coded and how it operates. What's really important for a competition lawyer to understand is how it's going to impact on competition. So can it make the market more competitive? Can it make the market less competitive? Could it be manipulated in a way that gives certain undertakings an advantage, whether that's at the expense of their competitors or of their consumers? So you have to understand its competitive role, but you don't necessarily need to understand how it has been built by the data scientists or by the engineers. When it comes to applying competition law in algorithm-heavy markets, I think the starting point is that undertakings should not deliberately interfere with the free functioning of algorithms in a manner that is likely to have anti-competitive effects. Whether this is by interfering with the algorithm itself, as we saw in shopping, where Google manipulated the operation of the algorithm, or whether it's by trying to, in some way, manipulate the inputs for that algorithm, as in the Guess case, where Guess was trying to limit the bidding on keywords in order to distort the auction process being run by the AdWords algorithm. That being said, however, competition law should not defer to inherently anti-competitive technology. And I think that this is very clear. 10 years ago, 15 years ago, many competition lawyers, competition policy specialists were saying the digital economy is just too complicated, it's too fast moving, there's so much of an emphasis on innovation that we shouldn't be applying competition law here, it's not appropriate. I think in 2020, it is very clear that we don't agree with that, that there are market problems in the digital economy that may require competition law intervention, and competition law should not defer to anti-competitive technology, whether that's a robot cartel, the most obviously problematic example we have discussed, or even where it's the widespread use of algorithms might reinforce other forms of anti-competitive harm, as in the RPM cases that we saw. So that's, I suppose, my conclusions when it comes to competition law today. But there is a very vigorous, contested, ongoing debate about whether the existing competition rules are adequate to meet the challenges of the digital economy and whether we should actually be reforming these or changing these in some ways in order to make markets work better. And so what I want to talk about for the final 3 slides of the presentation are some of the options for reform that have been suggested. I have to say, I'm not, if you kind of think about the 4 scenarios we've just discussed, it's clear that competition law can be applied to regulate algorithms, but it's a flexible tool already. So it's not necessarily, I think, obvious that we have to reform competition law, but it is something that is certainly being debated. I'm going to focus on the proposals for reform in the EU because that's where they're most well developed, I think. Could we go to the next slide, please? Thank you. So the first option for additional regulation actually has already been enacted in the EU. So this is Regulation 1150 of 2019 on promoting fairness and transparency for business users of online intermediation services. This is an EU-level piece of legislation which applies directly to all providers of online intermediation services, specifically in terms of their interaction with business users. So, for example, it would apply to the relationship between Google, the Google search engine, when it's providing advertising services to other businesses. It would apply to the Amazon marketplace platform when it provides listing services for online retailers of goods. It would apply to hotel booking websites when they provide booking services to hotel providers. And the regulation specifically imposes obligations on these providers of online intermediation services with respect to the terms and conditions offered. The title of the regulation says fairness and transparency, but really it's a question of fairness. So it just requires these operators to make very clear in advance what terms and conditions are being offered. Of particular interest for our purpose, when it comes to the use of algorithms, it requires those online intermediation service providers to clarify the ranking criteria used for algorithms and whether any form of differentiated treatment will be applied potentially for payment. It applies to all service providers. So unlike, say, Article 102, there's no dominance requirement. Even smaller online intermediation service providers are caught by this. The difficulty, perhaps, is the weak enforcement framework. It's because we're dealing with business customers rather than individual consumers. The logic of the regulation is that it's up to those customers to enforce their own rights. So they get certain rights in the regulation, but there's no public enforcement framework. The regulation makes requirements for internal complaint systems at the sort of online, the service provider level. It requires mediation to be put in place. There's a very vague obligation on member states to ensure the effective enforcement of the regulation, but there's no public enforcement framework sort of anticipated, and there's no remedies provided in the regulation. These weaknesses and the fact that there aren't really any substantive rights granted meant that even before the regulation came into force, legally applicable from July this year, in June this year, the Commission announced that it was already considering reforming or adding to the regulation, even before it sort of came into force as law, as part of an ongoing consultation, which I'll talk about in a few moments. So it's a kind of a starting point, but it's considered to be relatively weak in practice. A perhaps more successful proposal, certainly one that has caught a lot of public attention, is the possibility of developing ex-ante code of conduct for large digital undertakings. So whereas the regulation applied to all online service providers, this proposal, option 2, would be targeted only at the very largest digital undertakings. And this is a suggestion that is actually gaining popularity with policymakers in a very large number of jurisdictions. I'm going to focus on the EU proposal, but it's underway in Australia, in the UK, various other jurisdictions. The idea here is that specifically for these very big tech firms, they would be subject to a heightened level of scrutiny. They would be subject to more demanding ex-ante obligations, which would be set out in advance and enforced in the EU by an EU-level public enforcer. So they'd be subject to additional obligations, and these additional obligations would be policed by an enforcer with the power, if there was breaches, to actually impose remedies, to pursue these. The interesting thing about the EU proposal is that, and it's just a suggestion at the moment, the European Commission has been consulting with stakeholders over the summer as part of the proposed Digital Services Act package. It has said it will make an announcement later in the autumn as to what it's going to do in terms of legislating in this area. The EU proposal is targeted at the economic power that large online platforms acting as gatekeepers hold. This is not the same thing as market power. So even though the code of conduct would only apply to large digital undertakings, it wouldn't have the same scope of applicability as Article 102, because Article 102 focuses on market power. The concept of economic power or gatekeeper power is a rather different, and it has to be said, still somewhat undefined one today. It could, however, have quite a significant overlap in terms of scope of application with what we've discussed earlier, because the code of conduct could certainly be used to curtail the use of algorithms or dictate how these are developed in future. It could prohibit certain practices outright, or it could impose, for example, obligations of transparency or non-discrimination or fairness or whatever it might be in terms of the use of algorithms by these big tech firms. All of this remains to be determined as part of that consultation. I guess the only question I would ask here is, are we confident that public enforcers are best placed to determine this? Because what we're talking about is a code of conduct that could quite significantly constrain the behavior of big tech firms in the future. And when we're talking about very innovative industries, we're talking about perhaps even the development of business services that we can't even anticipate today. We don't know what new businesses are going to be coming on stream in 5 years' time. Are we confident that public enforcers are better able to second guess this than the big tech firms themselves? Are we sure that in the longer term, this code of conduct is actually going to increase consumer welfare, make the market work better, add to the sum of human happiness, if I was going to put it in that quite dramatic terms? So could we go to the last slide, please? So this, I'm about to conclude. This is my last slide with option 3 for additional regulation. This is quite an interesting one, I think, in light of what we spent the first part of the presentation discussing, which is the application of Article 101 and Article 102 to anti-competitive behavior in digital economy markets. And so we saw lots of examples where the existing competition rules were indeed flexible enough to be applied to address problems involving the application of often quite high-tech algorithms. Very modern markets, but competition law can adapt. However, there are numerous commentators who disagree with that assessment, or think at the very least that the existing competition framework has gaps in coverage, that even if it can address some problems, it can't address all competition problems, and so we need a new competition tool to fill the gaps within the existing competition framework. This term, new competition tool, is the one that's used by the European Commission. The European Commission is currently considering whether it should add to the existing competition framework with something other than Article 101, 102, whether it needs a third strand to the antitrust rules, specifically to address the problems arising from digital markets, algorithm-heavy markets. The proposal, as it stands today, quite closely resembles the UK market investigation regime, which is a quite unique aspect of the UK competition system. This regime enables the UK Competition Authority, the Competition and Markets Authority, to conduct in-depth reviews of markets that are considered to be not working well, to determine whether any feature of those markets generate adverse effects on competition. That's the legal standard. Is a market feature generating an adverse effect on competition? If such a market feature is identified, the CMA has really extensive remedial powers that it can apply in those markets to fix the problem. This includes structural separation of undertakings operating in the market. It includes things like price regulation, quite close regulation, access regulation. So it's a really powerful tool in the UK. The most important distinction with the ordinary competition rules is that you're focusing on markets that don't work well. So is there an adverse effect on competition arising from a market feature rather than anti-competitive behavior? So Article 101, Article 102 require you to identify something wrong being done by an undertaking, bad conduct. The new competition rule would completely sidestep that requirement. You just have to identify markets that don't work well. And so this certainly could be applied to limit or direct the use of algorithms by big tech firms. It might, for example, be a useful way to plug the gap in the application of, say, Article 101 or 102, where you have the widespread use of algorithms in a market. The use of algorithms is leading to less competitive conditions, something a bit like tacit collusion, a robot-type cartel. You could intervene under the new competition tool potentially in a way that maybe you couldn't under the antitrust rules. The only, I suppose, tentative objection I might raise to this possibility is one that I think follows from our earlier discussion, which is we've seen multiple applications, successful applications of Article 101 and Article 102 in digital markets. Even if there are gaps in the coverage of the competition rules, there's still a lot of coverage. The competition rules can be applied here. And I guess the question we might ask is, do the current gaps, or what are perceived as gaps, potentially exist for good reasons? Might we be over, I suppose, enforcing competition law if we bring in this new competition rule? Might it be regulatory excess? At that, I will leave it, and I would very much welcome questions, comments on everything that has been discussed thus far.
Thank you, Niamh, for that wonderful presentation. 오늘 던 교수님께서 발표하신 내용의 전반부는요, Competition Policy International에서 발간하는 Antitrust Chronicle 올해 7월호에 Algorithms in Contemporary EU Competition Enforcement, Evolution Before Revolution 이라는 제목의 글로 다시 볼 수 있고요. 사실 후반부에 내용이 더 어떻게 보면 흥미롭고 시사점이 많았던 것 같습니다. 그럼 청중의 질문에 대한 답변을 들어보는 시간을 가지겠습니다. So, Niamh, we already have a few questions that are on the window. The first question is, in the case where enforcers find that the undertaking has meddled with the algorithm in an anti-competitive manner, like let's take the Google shopping scenario. Is it possible for enforcers to restrict the use of the algorithm in a specific way? I mean, what the gist of the question would be, what can enforcers actually do about that?
So that is an excellent question, and I think the Google search case, the Google search shopping case, is a really problematic example of how you deal with that, because the Google shopping case actually started back in 2010. So it started 7 years before it was actually concluded, and the Commission initially tried to conclude it informally through commitments. And it went through, so Google proposed changes to its algorithm. The Commission market tested those, and that happened 3 different times. And the Commission, each time it went to stakeholders, the stakeholders came back and said, we don't like these changes. We think that the Google should do something else, something different in terms of how it modified the algorithm. And eventually the Commission lost patience, and it just took an infringement decision. In the infringement decision, the Commission said, this is a violation, you need to go fix it. But it gave no indication of how Google was supposed to fix it. And I think that's particularly problematic when you look at that past history, where Google itself had proposed 3 different ways to fix the problem, and the Commission had never been satisfied with it. So under EU competition law, yes, there is the power to impose behavioral or structural remedies. I think many jurisdictions have that, but it's very difficult to actually figure out what those remedies are going to be. And I think if you're cynical, if you're a competition authority that just wants to punish a big tech firm, you just do what the commission did, which was say, it's your problem, you caused it, you go solve it. But that leads to quite significant difficulty subsequently. And if you look at the sort of subsequent history of the Google search shopping case, there has been a lot of disagreement as to what sort of remedies Google should adapt. It subsequently changed its practices, and stakeholders still say there's a problem, that it's just changed the form of the problem. So it's really quite complicated in terms of second guessing this. That doesn't mean that the commission shouldn't take these cases. And I think Google search shopping is probably, I think it's a good case on balance. I think the one thing I wish the commission had done in the case was be honest about how it's a new market, it's a new problem, and say, we're making new law here, which they sort of refused to do because they wanted to impose a really big fine. So the only measure they actually imposed on Google was this 2.4 billion euro fine, which of course makes the front page of the New York Times and the Wall Street Journal the next day that Google has been fined by Europe, and it becomes a big transatlantic question. But I think developing these remedies is going to be very important, but it is very difficult in practice.
The next question relates to something that has come up in the news. So Apple, and it relates to these platforms trying to regulate their businesses, perhaps because of public or regulatory pressure. So Apple announced that it was upgrading the iOS and it was going to restrict tracking by third parties and changing it to an opt-in system, etc. Google mentioned the same thing about Chrome and said that it would also restrict cookies and and these tracking surveillance techniques. So as of now, it seems that this surveillance tactics or tracking will become more difficult. What do you envision how this will impact competition going ahead?
That's again a great question, because you have, I think, these two currents of thought and these kind of these two strands of regulation, which people are both very concerned about, but there is a bit of an ambiguous relationship between the two. So on the one hand, this concern that these very large platforms have really significant market power, economic power, that they're becoming unregulatable monopolies. And on the other hand, this concern about data privacy. And this is a particularly important issue in the EU because there's actually a fundamental right to data protection under the European Charter, which is quite a strange right. It's different to the right of privacy. So there's two distinct rights in EU law: data privacy and sort of individual human privacy and family and private life. And there is, I'm sure many people will be familiar with the GDPR, which was brought in a couple of years ago, which has been this hugely important, influential, very, I suppose, high-profile regulatory development, which is sort of intended to try and have greater control over the misuse, the collection of private data. The difficulty with the GDPR when it comes to sort of a competition perspective is that complying with the GDPR is actually quite difficult. It's quite expensive, it's quite technologically complex. And there is an emerging, I suppose, realization that actually it's likely to further entrench the market power of the big players. So Google, Apple, Facebook have literally hundreds of people employed to figure out how you comply with the GDPR so you're not going to have regulatory trouble. The smaller players in the market find it much more difficult. So there are a number of provisions of the GDPR which people say, well, maybe that will help things like data transfers, and you have a right to kind of transfer your data from one provider to another, but none of those really are designed to protect market power. And so there is, I think, quite an uncomfortable relationship between data privacy protection and, I suppose, new market entry, and certainly the potential to kind of limit third-party tracking by other players, by rivals of Google and Apple. While that seems great if you're thinking of this from a data protection perspective, if you're thinking of this from a competition law perspective, it maybe becomes a little bit more, it becomes a little bit more problematic, because it could be another feature of the market in addition to network effects and so forth that is just reinforcing this power. Maybe the last thing I would say is that I think there is a slightly uncomfortable relationship between data protection and competition law anyway, because data protection just works from the assumption, or at least in the EU, the data protection rules are incredibly protective of personal data, and they're hugely suspicious of any use of that data, any collection, any selling, whatever it might be. Whereas I suppose maybe as a slightly cynical competition lawyer, what I might say is, but actually, if I want to use my personal data, if I want to sell it to get a free service like the Google search shopping, the Google search engine, or free Google Maps, or whatever it might be, to use Facebook, and actually I'm not that bothered that Facebook's going to try and sell me a display ad, why can't I do so? If I think it's a good deal, why can't I make that call?
The next question, there's actually many questions coming up, but I'll have to curate them due to the time. So next question relates to the P2B regulation. As you pointed out, it really seems to lack teeth. And as you said, the Commission is thinking about reforming it already. So the question is, if we want to really have it to have impact, what should be done?
Great question. One which I think it's really hilarious that before the regulation even came into effect, the Commission has started to consult on, they're very clear, it's not reforming it or changing it, it's just adding to it. I suppose, thinking as a competition lawyer, in these scenarios, the real problem is where an online intermediation service provider has market power. So if they don't have market power, just switch to a different provider. If you're a business user, you don't like the terms you're being offered by your service provider, go to a different platform. If, however, the platform you're using already has market power, well, then that might not be so straightforward. So, you're a hotel, you kind of have to use one of the large booking platforms, because otherwise you're not going to find any consumers. And so I suppose this is where this second idea of specifically targeted codes of conduct for the very large players comes in. Maybe we need to separate out everybody, all sort of online service intermediation service providers, from those which have market power, where there is a kind of a specific risk of exploitation of the business consumers. And there is actually likely to be quite a significant overlap between the two categories, I think, between the code of conduct and the online intermediation service regulation. This, I think, I think you kind of have to go beyond it. Clarification is useful. What I think will be useful about the regulation is if you have, say you have Google, and Google is systematically just favoring its own products. If it has to write that down in the terms and conditions, so that it says to any users of, it says to comparison shopping services which are maybe buying advertising space, just to let you know, even if you buy this advertising space, we're still going to give our own service preference, well, then maybe it will be a little bit more difficult to justify. So that the clarity, the transparency might have that almost like a public shaming type effect. But I don't know that Google has very much shame. I think it's it's maybe a little bit immune. But I think it's a really good question. I really don't understand, I have to say, the logic behind the regulation, because it's so prescriptive. I mean, they had to go through the legislative process. It's quite difficult to bring in legislation in Europe, and yet it doesn't really seem to say anything. It has almost no content. It's a strange thing.
I think we'll have to entertain the final question. I'm going to bunch up a few together. And it really probably relates to one of your points, but mainly to the Google Shopping scenario type of algorithmic regulation. So if we want to restrict companies from meddling with algorithm that we deem facilitates competition on the merits, Does it, however, run the risk of ossifying the development of algorithms? Are we actually preventing the development of algorithms or competition itself? The reason why I think a lot of our viewers are asking that is because Korea is also actively considering various legislative proposals, which range the whole gamut from something similar to the P2B regulation all the way to the new competition tools. So that's probably we'll have to have that as the final question.
Great question. And I share the skepticism of some of the viewers here. In Europe, this is 50% about making markets work better, and this is 50% hugely a political play, I think. It's about the European Commission making these really broad, brave statements about how Europe is going to come and intervene and protect you from the evils of the big monopolist. I mentioned very briefly that there was a second Google case which had an even higher fine. So the fine was 4 billion euro, just 4.3 billion euro. But they set the fine at a level that when you converted it into US dollars on the day of the fining decision, it was exactly $5 billion. Because it was not just about signaling to Europe, it was also about signaling to the world. This is what we're doing. We're tackling big tech. And I think that that's important. I think that somebody should be maybe reminding these big companies that there are powerful regulators out there and that they're not completely immune. The difficulty is when it comes to substantive competition law, when it comes to the actual effect of these cases, absolutely. If we start to have a regulator in Brussels, a bunch of lawyers deciding what is an acceptable algorithm and what is not an acceptable algorithm, I have no idea how you would decide that. You know, as a competition lawyer, it is completely beyond my capabilities. And I'm not even sure that I would know how to deal with expert evidence on that. So I get a couple of data scientists to give me their views. But ultimately, I don't think there is any clear view on this. And of course, when we talk about the digital economy, we're not just talking about products that already exist and how we will shape their future development. We're talking about products we don't even know exist, that might exist in 5 years' time. So I think there is a huge amount of potential danger involved in this. Hopefully, I'm sure there's a better regulation agenda in Europe as there is in many countries, and hopefully if you can build in some flexibility. But I absolutely agree. I think you need to be very careful about actually being prescriptive. My very last point is, of course, the flip side of that is that you could have, back to the Google search shopping case, where the commission just said, well, you go fix the problem. You created the problem, you fix it. That's also not that helpful in terms of the firms. So you have a difficult line between, if you identify a problem, what do you do with that? If you identify a problem, but there's no clear solution, should you intervene? How do you intervene? All of these things, I think, they're broader competition policy questions, certainly beyond the scope of this seminar, or extending beyond, continuing beyond.
Difficult question indeed. 시간이 다 되어 아쉽지만 방금 질문을 마지막으로 마치려고 합니다. 그 다음 웨비나는요, 이번 주 금요일 오전 10시에 서울대 박상철 교수님의 사회로 인공지능 거버넌스에 대한 구글의 시각이라는 제목하에 차리나 차우 박사님이 발표할 예정입니다. 그 이후에도 9월 29일까지 차등 프라이버시의 창안자인 하버드의 신티아 돌 교수님을 포함한 4차례의 웨비나가 여러분을 기다리고 있습니다. 아무쪼록 많은 것을 얻고 또 생각해보는 유익한 시간이 되시길 바랍니다. 그 뒤에서 수고해 주신 이니시티브의 스태프, 연구원들과 조교들께 감사의 말씀을 드리고요. Niamh, it was a privilege to have you speak today. Thank you again. I hope we will have the opportunity to hear you speak in person here in Seoul one day.
Thank you so much. It was great to be here. Thank you.
오늘 참석해 주신 여러분 모두 편안한 저녁 보내시기 바랍니다. 감사합니다.